A landmark decision could pave the way for stronger union involvement in workplace bargaining. The federal court has ruled invalid the workplace agreement at the Pilbara iron ore operations run by Rio Tinto. There are fears it could spark wider industrial unrest throughout the mining industry.
Rio Tinto struck an agreement with its Pilbara workers in 2008 without union involvement after such arrangements were banned by the Federal Labor Party. The Construction, Mining and Energy Union challenged Rio Tinto, and the full bench of the federal court has agreed the agreement is invalid.
It appears to mean that a business can't negotiate direct workplace agreements or individual contracts with workers, but that the unions have a right to become involved.
The decision leaves the mining industry in uncertainty. Other miners like BHP Billiton negotiated similar agreements and could also face challenges. The union says the fight's about fairness, not money.
This wasn't about pay, this was about maintaining the rights that employees have to be represented. It was about employees not losing conditions.
The union also rejects fears by the state government that the judgment could lead to a repeat of unrest seen in the 1970s and 80s when unions caused havoc in the Pilbara and strike action impacted on iron ore production.
These companies will lose their competitive edge, the cost of doing business will go up, they'll have industrial action on a regular basis.
And it's not just miners who'll be affected because all non-union collective agreements are now under the spotlight.
The real damage will be done elsewhere in Australia if this flows on. The mining companies can afford to pay, manufacturing companies cannot afford to pay.
Rio Tinto says it's considering appealing to the High Court. In the meantime, employees will continue to receive the same pay and conditions. BHP Billiton says it's seeking legal advice about how it will be impacted by the federal court finding. Mincy Chung, ABC News.